Minister for Justice on the platform. Welcome, Deputy Minister, and the team of legal people from your department. The Parliamentary Legal Services is also on the platform. Welcome, everybody. Our members will then move into the first agenda item, which is the committee consideration and adoption of the Judicial Matters Amendment Bill. Just to remind members that the bill provides for amendments to 19 different acts administered by the Department of Justice and Constitutional Development. And in our first briefing on the bill, members welcomed many of the clauses which would obviously ease the administration of justice. In response as well to our advert for public comment, members will recall that we received only one submission, which was in support of the bill and specifically in relation to the payment of admission fine and the expungement of criminal records. And this was also responded to by the department in our previous meeting. I'm going to now opening up to honourable members if you have any other issues for consideration for the committee on the bill that you would want to raise at this point, please raise it. If you do not have any additional issue, then I would propose that we move the bill without amendment for adoption. And if there's any member that would want to move for the adoption of the bill without amendment, please give me an indication.
I move, Honorable Chair, Honorable Bartlett. Move for adoption of the bill.
Okay, Honorable Bartlett moves for the adoption. Any seconded to that? Is there any
seconds? I second.
Okay, thank you very much, Honorable Ndongeni, Honorable Dodovu. Are there any abstentions? And okay, thank you very much, Honorable Ndongeni, Honorable Dodovu. None. Any abstentions? Are there any abstentions? Okay, none. And thank you very much, Honorable Ndongeni. So we adopt the bill without any abstentions. Are there any amendments? The second agenda item then, honourable members, is with regard to our consideration of the adoption of the committee report on the Judicial Matters Amendment Bill. The report is being projected. Thank you, Gershwin. The report was also sent to honourable members. I'll ask Gershwin perhaps then to just briefly take us through the report. Gershwin.
Good day, members, again. Presenting the report on the Judicial Matters Amendment Bill, Bill 7B 2023, National Assembly Section 75. As the chairperson has indicated, members, the committee is proposing adoption without proposed amendments. The bill will obviously go straight to the NCOP and from there to the President. In dealing with the bill, in terms of the public participation process, we invited stakeholders and interested persons to make written submissions and advertised on electronic platforms and newspapers from 3 November. The deadline was 17 November 2023. We only received one submission from one individual. The department briefed the committee on the bill, and we are now presenting the report for the members' adoption. If there's anything that members would like to add, I'm handing over back to you, Chairperson.
Thank you very much, Gershwin. I'll just take it from what Gershwin also said. Our members, are there any additions and or corrections that you would want to make to the report? Please give me an indication. Okay, if there are none, then our members, if there's a mover for the adoption of the report.
I do move, Chair. I'm Dodov.
Thank you very much, Honorable Dodovu moves. Any seconder?
Malik, I second, Honorable Chair.
Okay, Honorable Bartlett Okay, Honorable Bartlett seconds. Are there any objections? None. Abstentions? Okay, none. Thank you very much, Liz. I think the report is also then duly adopted. Our members will then move on to the next agenda item, which is in relation to the report with regard to the executive undertakings made by the Minister of Police during the NCOP's taking Parliament to the people. We engaged the Minister of Police in our previous meeting. Once again, our members, the report was sent to members, and I would take it as being read, but I would also then request Gershwin to take us through, taking note of I think the beginning bit of it actually provides more information in relation to the executive undertaking. Then I think that in the report are the responses by the department, and perhaps what is more important would be the observations of the committee and the recommendations that we make. Gershwin, perhaps if you could quickly take us then through the report, and I suppose you could go to the quicker, we could move quicker to the observations. Gershwin.
Thank you, Chairperson. Members, as the Chair's instructed, I'm just taking us to the observations and key findings. The committee notes that the department in relation to the implementation of the executive undertakings under review, the committee made the following observations. The committee noted the issues of policing, safety and security was prominently brought to the delegation's attention in UGU District. The committee commended the Station Commissioner for being on top of issues of crime, communication and interaction with the community. The committee urged the Minister to continue building on the important collaboration between the police and communities in the fight against crime. The committee acknowledged the Minister's report that a means of travelling and transportation was offered to the community police forums to enable their effective functioning. With the necessary support, equipment and material support, the CPF must work with the police in the fight against crime, as they are an important component of the whole police service in our country. The committee noted the Minister must consider giving priority in the next financial year to CPFs. On the issue of discipline, the police members, the committee appreciated the measures taken by the department. And the committee congratulated the Minister on the work they are doing within all provinces, including the Western Cape. The committee noted that South Africa has a national police service that must serve the whole country. In terms of the recommendations, the committee urges and recommends the department step up its efforts to remedy the challenges with regard to CPFs, finalize the draft resourcing model, properly resource CPFs in the next financial year. The committee acknowledges that the fight against crime requires collaboration, and therefore recommends that the justice, crime prevention and security cluster should work together in the fight against crime. The committee encourages the department to ensure that all necessary disciplinary measures are taken against implicated police members. Police members should conduct themselves in a manner above reproach to gain the confidence of the public in the fight against crime in South Africa. And the committee recommends that the department should continue to work closely with communities and CPF structures to ensure that it understands the nature of crimes within specific communities in order to effectively fight crime. The committee urges cooperation and collaboration at all levels in the fight against crime. Thank you, Chairperson.
Thank you very much, Gershwin. Our members, that is the report. Are there any additions or corrections that members would want to make to the report? Okay, I don't see any hand. Okay, if members are happy with the report, then is there any member that would want to move for the adoption of the report?
I move, Chair, by Honorable Dodov.
Thank you very much, Honorable Dodov. Is there any seconder?
I second, Chairperson.
Honorable Chairperson.
Okay, Honorable Maleka seconds. Are there any objections and or abstentions? Okay, none. Our members, thank you very much. The report is duly adopted. Members, we'll then move to the next agenda item. This is in relation to the executive undertakings made by the Minister for Home Affairs during the NCOP's taking Parliament to the people. And as indicated, we also met with the Minister of Home Affairs in our previous meeting, and I would suggest members we follow the same route in terms of Gershwin presenting the report to members. Gershwin, over to you.
Thank you, Chairperson. Members, in terms of the observations and key findings, in noting the progress report given by the department in relation to the implementation of executive undertakings under review, the committee made the following observations. The committee welcomed the presentation and update by the Minister. The achievements have led to an improvement of services, especially in the mobile support to rural areas. The committee further requested the department to ensure that it increases its efforts throughout the country to target the rural areas, the villages, the farm areas, and so forth, because those vulnerable communities need this service the most. The committee noted an improvement in the registration of children at birth, with the service having greatly improved the speed of capturing and registering of the child. However, the committee noted that the accuracy of capturing must be improved. The service must be excellent in its execution. Past times, there was no care with the registration of the child's name. This became noticeable in a person's life who lived with an incorrect name or incorrect birth date. The service has greatly improved over the years, but we need to find ways of addressing the accuracy and improving it in this current dispensation through staff training, error monitoring, and quality control processes. The committee welcomed the response from the Minister explaining the rectification process that exists and the initiative by government to employ 10,000 unemployed graduates to digitize 350 million records. The committee noted the improvement in office space with regard to Menden Park and Pinetown and the improved access to the services of Home Affairs. Members raised that South Africans appear to always be seeking the services of the Department of Home Affairs. The response of government must translate to meeting the needs of the customers, the citizens, through improving the convenience and providing a satisfactory experience if we are running a caring government. The committee congratulated the Minister on following up on undocumented foreigners and citizens, but the issue of crime and corruption remains a question that needs addressing. Members provided verbal evidence of known persons who fraudulently produced visas with a birth certificate. The matter has been brought to the attention of the authorities, but not much has been done about it by immigration officials or the police. The Minister requested the information from the member of the counter-corruption unit to follow up on the alleged fraudulent activity. The Minister further corrected the assumption that the department is afraid to tackle people from other countries and reminded the committee of successes in the past year. The department, and in particular with a Pakistani national, was fraudulently producing passports. In 2023, the department deported 67 Pakistani nationals at our Tambo International who were entering into the country using illegal visas. In the same week, the department deported a further 11 persons from the same country who were entering through Cape Town International Airport. The department also managed through the court to deport a Russian lady who came to South Africa without documentation, claiming to be a refugee. The court determined the accused had to apologize to South Africa, and she was banned from entering the country for the next 5 years. The committee requested clarity on how far the engagement with the CETA were progressing and whether there was some kind of time frame when this matter will be addressed. The Minister noted that the Department of Home Affairs is very dependent on CETA, and if anything happens because of the problems at CETA, Home Affairs will be the hardest hit at any one time, even though many government departments are also serviced by CETA. The Minister indicated they had raised their concerns and requirements and are engaging CSIR on the matter. The Minister reported that he has already written 3 letters to 3 different ministers who are in communication dealing with CETA, but the situation remains unresolved. And the Minister has escalated the matter to the President, and they are hoping some progress will come from this. In terms of the recommendations, the committee recommended that the department focus its efforts on increasing mobile support in rural areas throughout the country. In respect of registration of children at birth, the committee recommended that the department should implement training to ensure that upon registration, children's names are recorded correctly. This is a historical problem that the department should address with urgency. The committee urged the department to prioritize the needs of citizens in all their work and to ensure that their services are rolled out in a manner that takes into account the needs of citizens and communities. Members emphasized that service delivery is of paramount importance in addressing the needs of citizens effectively. The committee encouraged the department to continue with the good work it is doing in addressing corruption via the counter-corruption unit, as these steps are progress towards promoting and fostering respect between the department and citizens in terms of service delivery. And then lastly, the committee recommended that the department makes every effort to ensure that CETA is rolling out its services effectively and timely to improve service delivery throughout the country. In this regard, the department should make an effort to hold CETA accountable to deliver its service in a timely fashion. Thank you, Chair.
Thank you very much, Gershwin. Once again, honourable members, are there any additions and or corrections that you would want to make to the report? If none, then honourable members, is there a mover for the adoption of the report?
I move, Honorable Chair.
Thank you very much, Honourable Bartlett. Is there any seconder? Any seconder?
I second, Chair. I second, Chair.
Okay, thank you very much, Honourable Dobu. I think that was also Honourable Motsamai in the background, but thank you very much for seconding the report. Are there any objections? Abstentions? Okay, if none, thank you very much, honourable members. The report is duly adopted. We'll then move to the fifth and final agenda item, honourable members. It's in relation to the briefing that we received by the Department of Justice on the public submissions to the regulation, to the RICA bill. Apologies, yeah. Remember, just in terms of where we are, what happened within the process, we received a briefing on the bill on the 15th of November 2023. The bill addresses issues as a result of the Amabungane case, where the Concord declared certain sections of RICA unconstitutional. We were also informed that the bill is intended as an interim measure to address the constitutional defects, as the intention is to overhaul RICA, which the department is currently embarking on consultations on, and is expected to introduce the bill by next year, June, to Cabinet. In terms of our own process, we advertised the bill for public comment, and in response to that, honourable members, we received 3 submissions. One submission was received on the bill from Premium Ideas South Africa, and the second was from an individual, Lawrence Mashava, and the third submission was from Jane Duncan, Professor of Digital Society, School of Social and Political Sciences from the University of Glasgow. To which I think in today's meeting, honourable members, the department will respond to these the comments that we received. Let me hand over then to yourself, Honourable DM, to then take us through the department's responses to those comments.
Thanks, Chair, and good morning to the members. I mean, as you've correctly said, the bill is simply addressing the orders in the Amabungane case, for which the deadline is early February. So as with the National Assembly, some of the submissions are on the content of the bill, and some of the submissions are on things that people would like to see in RICA that are not addressed by the bill. And with those, we've said that, so it's issues of SIM cards, the Section 205 subpoenas that are issued by the court in terms of the Criminal Procedure Act. And for those, we've said those will be dealt with in the complete revision of RICA. So I'll hand it over to the officials from the department. I think it's led by DDG Pillay, Kale Pillay, to go through the submissions that are made. I'll comment further later. Thanks, Chair.
Good morning. Good morning, Honourable Chairperson and members of the committee. I'm joined today by Ms. Alison Botha, I'm not sure, Gershwin, if you want to give me or her sharing rights. We would like to share that document on the screen, if it's possible.
Hi, good day, Kale. I've given Alison sharing rights, but I'll give you as well.
No. If Alison is fine to flight the document and speak to it, then I'll hand over to her. Thank you.
Thank you, Chair, and thank you to the DM and to my DDG for that introduction. Can I just check if I'm audible and if my screen is visible?
Yes, you are. The screen is visible as well.
Thank you. Let me jump into it, and good morning to you, Chair, and good morning to the members. Let me jump straight into it. On clauses 1, 5, 6, 8, 10 to 12, there were no specific comments received. And the way this document is set up is that we're going to go through specific comments on the bill first and general comments on the bill later on. So on those specific clauses, there were no comments received. In clause 2, which deals with the insertion of chapter 2A in the RICA Amendment Bill, that introduces 15A through D, and the concepts of designated judge, review judge, the powers and functions of the review judge, and the tenure of the designated and review judges. On this clause, we had a comment by Jane Duncan, who indicated that on 15A, which deals with designated judges, that the appointment process is adequate only to the extent that it means that the appointment must be made by the minister with the concurrence of the Chief Justice. And as a result of the public hearings and deliberations in the Portfolio Committee, the decision was taken to make an option of having more than one designated judge available. Ms. Duncan indicates this is a welcome insertion and brings the bill into line with RICA. Her recommendation is that the bill could make it clearer that the appointments of the designated and review judges should be made with the concurrence of the Chief Justice. On this recommendation, the department disagrees. The bill is sufficiently clear regarding the appointment of judges and the involvement of the Chief Justice, and this is what is meant by the phrase "in consultation." The department's of the view that there is no need to amend the bill because this is a trite phrase in legislative drafting and it's well understood and accepted. Ms. Duncan comments on 15B, which deals with the review judge, that for a better use of resources, that the automatic review ought to be built into the process once the subject of surveillance has been notified of the surveillance, and they can then be included in the review if they wish to contest that surveillance, supported by the public advocate. So the public advocate, Ms. Duncan argues, would be available at 2 stages, when the initial decision is being made and when the surveillance subjects contest the basis for decision-making at review stage. However, automatic review doesn't depend on their doing so. It would take place whether or not the subject wishes to contest. Response on to this comment on clause 15B is that the issues of review at the end of the surveillance process and the introduction of the public advocate will receive attention during the review process for the overhaul of RICA. Also, this comment seems to suggest that the automatic review process serves the purpose where it is currently located, that is, at the decision-making process of the designated judge, and at the end of the surveillance process, regardless of involvement by the surveillance subject at the end of the surveillance process. It doesn't seem to follow that review at the end of the surveillance process, as it's suggested, which is not prompted by an aggrieved subject of surveillance or involves that subject, would yield any real or meaningful relief. To follow the suggestion made to its logical end, the automatic review would be conducted at the end of the surveillance, but it's unclear at whose instance this review would be triggered and what the purpose of it would be. If the automatic review results in the conclusion that the interception application should not have been granted, and the subject of interception is not a part of that review process, what is the meaningfulness of the outcome of the review process for the person who's affected by it? The person would need to be notified of the outcome, presumably, but they would still need to proceed to exercise their rights through ordinary court and civil processes. So practically, in all review matters, the person seeking a review would be required to act positively when seeking the review of a decision. This includes, for example, instituting an application for review. The other method of automatic review involves one court, usually a lower court, forwarding the decision and all related documents to another court, usually a higher court, for a review of that decision. Ms. Duncan goes on to make a comment on Clause 15C, which deals with the powers and functions of the review judge. The bill is not clear on whether the review judge will have access to remedial powers, and that includes making orders, cessation of surveillance, destruction of intercepted information, or payment for compensation if it's found that decisions were flawed. The department's response to that is that the bill empowers the review judge to consider and either confirm, vary, or set aside any decision made by the designated judge. And it also provides that any decision made by the review judge must be executed immediately upon receipt by the applicant. This will necessarily include the power to make orders, cessation of surveillance, and destruction of intercepted information, among others. It is a broad power. The absence of a clause on issues of compensation does not prevent any person from approaching a court for relief and compensation. On Clause 15D, Ms. Jane Duncan comments on the tenure of designated and review judges to say that the fact that the designated and the review judge will enjoy substantial tenure for a non-renewable period not exceeding 7 years is not sufficient to provide them with security of tenure. This is because, while the maximum period of their tenure is clear, it's not clear what the minimum period of their tenure would be. She recommends that the section be amended to make clear what the terms of the tenure are, to avoid the dangers of judges becoming subject to regulatory capture. It may be better to restrict appointments to a non-renewable term of 5 years. In the same way that one judge may not be enough at the decision stage, one judge is also likely not to be enough at the review stage, and the establishment of a tribunal could be considered. Her recommendation is that the bill could state the tenure of both judges is for a non-renewable period of 5 years, and that the review judge should be retained, the consideration given to including more review judges and establishing a review tribunal with remedial powers. The department's response is that we disagree with the suggestion to reduce the term to 5 years. The continuity and the skills handover in this function are critical, and a longer term allows for the judge to build and amass skills pertinent to this role, which in turn allows for greater capacity and improved turnover. Further, the suggestion to have a longer term was reached as a compromise between multiple government stakeholders through a series of consultations. The department also does not agree with the suggestion to make provision for a minimum period. It's not standard practice to provide for a minimum period of appointments, as circumstances may require a judge to be released from his functions for various reasons, including their personal requests. More generally on the ex parte process, Ms. Duncan comments that it's possible that the review judge was introduced as a safeguard to respond to the ex parte problem identified in the Amabungane judgment issued by the Constitutional Court. The court left it to Parliament to decide how best to respond to these matters, but with the proviso that its solutions would need to address the inherently one-sided nature of the process. The purpose of the ex parte system or requirement is to ensure that there is an adversarial element introduced into the system. The review judge does not satisfy the ex parte requirement as it is not an adequate or appropriate safeguard and fails to introduce an interrogative element. In its response to the Portfolio Committee on the bill, the department conflated two issues that ought not to be conflated. that is, automatic review and the ex parte issue. Any solution to the ex parte problem must address the issue that the judges do not get to hear the other side of the argument, which undermines the audi alteram partem principle and doesn't elevate the process from being an inquisitorial one to an adversarial one. The bill fails to grapple sufficiently with this problem and the advances made.
Okay. Honorable Dodovu and Honorable Dlamini, could you kindly mute your mics? Okay, Shunki. Okay. Honorable Dodovu, Honorable Dlamini, your mics are still unmuted. Okay, thanks. Please continue. Ms. Botha.
Thank you, Chair. The bill fails to grapple sufficiently with this problem and the advances made internationally in how to respond to it. Ms. Duncan's recommendation is that the bill could make provision for a special advocate to defend the interests of the surveillance subject. The department's response to this general ex parte process comment is that the bill addresses the ex parte nature of surveillance applications in response to the issues raised in the Amambangane case in two ways. First, the introduction of an automatic review conducted by a review judge, and the introduction of a mandatory post-surveillance notification to the subject of surveillance. These are both critical safeguards that were discussed and considered in the Amambangane case. An automatic review has been introduced to address the dual issues of the pitfalls of ex parte applications in terms of RICA and the suggested automatic review that was considered by the Constitutional Court Miramotu. Clause 2 of the bill provides for a review judge as a safeguard to deal with the fact that applications for interception directions are made on an ex parte basis. The bill empowers the review judge to consider and either confirm, vary, or set aside any decision made by the designated judge. And it also provides that any decision made by the review judge must be executed immediately upon receipt by the applicant. The Amambangane judgment indicates in paragraphs 49 to 54, and in particular in paragraph 52, that an automatic review may be considered as a possible safeguard to deal with the ex parte nature of the applications. The department has in fact taken the suggestion made by the Constitutional Court a step further by establishing a separate review process by a separate judge to ensure greater and more effective safeguarding of rights through the automatic review process. The department disagrees that the purpose of the ex parte requirement is to ensure that there's an adversarial element introduced into the system. This is but one option available to address the ex parte requirement, and the issue of a public advocate is an issue that will be considered in the comprehensive review of RICA. The department notes the comment that there's a conflation of issues regarding automatic review and the ex parte issue. This comment is premised on the view that the process should include an adversarial element, such as a public advocate. As explained above, the department's of the view that an automatic review is a solution to the ex parte issue because it affords an added layer of protection against abuse, and it brings a fresh set of eyes and another objective mind to bear on an application for surveillance. The department conducted fairly extensive research into the concept of a public advocate, including looking to examples in other jurisdictions. And it's clear from this research that there is no uniform approach to this issue, the scope of powers and the use of public advocate in surveillance legislation. The issue of post-surveillance notification has also been introduced in response to the issues raised in Amambangane on ex parte. Clause 4 of the bill introduces Section 25A in RICA. The default position is that the subject to surveillance should be notified of the surveillance within the time specified, and this can only be deviated from in exceptional circumstances, which must be set out in an application by a law enforcement agency. The fact that there's now a mandatory post-surveillance notification is another important safeguard against the ex parte nature of surveillance applications because the subject is now required to be notified of the surveillance. Another comment that we received on clause 2 is from V. Al-Mashava, who indicates that paragraph 6 of the order requires that there must be adequate safeguards to address the fact that interceptions are sought and obtained ex parte. The explanatory memorandum does not explain how adequate safeguards have been provided for in the bill. There's no specific clause dedicated to section 1716(7)(a) or paragraph 6c of the court's order. The department's response is that the ex parte nature of the direction sought has been sufficiently dealt with in the bill, and we refer to the extensive response to the comment above. On clause 3, which deals with the insertion of section 23A, and that deals with the disclosure that the person in respect of whom direction, extension of direction, or entry warrant is sought is a journalist or practicing lawyer. Ms. Jane Duncan has commented that this provision is the same as in the Amabongane judgment. However, part of the clause has been omitted. The protection afforded by the bill is weaker than the protection afforded by the Constitutional Court for the period of suspension. Requiring the judge to satisfy themselves that the direction is necessary is a high test. To fulfill this requirement, the direction needs to be more than merely convenient and cannot lead to the required result of solving serious crimes, protecting national interests, using less invasive means, and protecting vital interests. Placing journalists and lawyers under surveillance should be an investigative method of last resort. Ms. Duncan's recommendation is to include the following clause, which was included in the Amabongane reading in provision, and that reads that the designated judge must grant the direction, extension of the direction or entry warrant referred to in subsection 1, only if satisfied that it is necessary to do so, notwithstanding the fact that the subject is a journalist or practicing lawyer. The department's response is that we disagree with that recommendation. The bill does omit that sub 2 because it is unnecessary for inclusion. The judge already necessarily exercises the discretion when considering an application where a journalist or practicing lawyer is a subject of the application. And this discretion need not be restated. It is accepted as part and parcel of holding judicial office. It's also clear in the wording of the bill, which states in proposed 23A2, if a designated judge issues the direction, extension of direction, or entry warrant, he or she may do so subject to certain conditions as may be necessary. On clause 4 of the bill, which inserts section 25A, and that deals with post-surveillance notification, Ms. Jane Duncan comments that it largely mirrors the reading in by the Constitutional Court. Sub 2 has been added to the provision in the judgment, is too broadly framed and could lead to an indefinite suspension of the notification requirement. The judge merely must satisfy themselves that the notification has the potential to impact negatively on national security, and this introduces a speculative element. The uncertainty could be reduced by specifying the adverse result of the notification, such as death or physical harm to an individual, fleeing prosecution or prevention of evidence tampering, and the delay should be necessary to prevent those adverse results from occurring and for no longer than that. There's no requirement for the judge to provide reasons for their decisions, and this leaves the subject unable to assess the basis for issuing the direction and unable to protect their rights. She recommends that the clause on national security should be replaced with a clause that allows for delayed notification in life and limb situations and should set an upper limit for the delay. The RICA judges should give reasons for their decisions, which should form part of the post-surveillance notification as a default. Consideration could be given to adapting the mechanism for post-surveillance notification prescribed by the High Court, where decisions to delayed notification should be referred to the review tribunal. The department's response to that comment is that in making a decision, the designated judge must consider the reasons provided for a request not to give notification. The department's of the view that judges must be entrusted to properly discharge their functions impartially and fairly, taking into account all relevant factors, including balancing national security interests and privacy rights. Further, the judge will not be required to speculate on the potential to impact negatively on national security. This will need to be set out by the law enforcement agency making the application for the delay of the post-surveillance notification, will then need to adequately substantiate the reasons therefore in that application. The judge will then be required to apply their minds to that application and exercise judicial discretion to account all relevant factors. It is not merely a speculative exercise by the judge, but it's a process that follows settled civil law procedures. The provision also empowers the designated judge to allow the withholding of a notification for a period that the designated judge may deem necessary based on the reasons provided in the application. It's not clear why national security is not a sufficient justification for withholding notification. It may be that an upper limit on delayed notification may not be feasible in all instances and cannot be rigidly applied, particularly if that upper limit frustrates the purpose of the surveillance. Also, imposing a life and limb restriction in all instances may not be feasible, given the nature of the threat to national security giving rise to the surveillance. Not prescribing a more precise definition of national security allows for law enforcement agencies to motivate for a range of risks falling within the RICA framework. And on this, please see our responses above. On the issue of RICA judges providing reasons for their decisions to the subject of surveillance, this is an issue that the department will consider in tandem with the content of post-surveillance notifications. The proposed recommendation introduces the idea of a review tribunal, and this delves into issues for a broader review of RICA. It's understood that this request is based on the review or appeal of that decision, which the subject of surveillance can undertake once they're notified. The release of information will then have to be managed in order not to pose a threat to the purposes of RICA, whilst also protecting privacy rights of the subject of surveillance. Clause 7, which deals with the insertion of Section 37A and the management of data, Ms. Jane Duncan comments that including these procedures in regulations without adequate guidance in primary legislation is inadequate in that it moves the legislative process into a subsidiary process that's unlikely to be ventilated to the extent that legislative changes in the parliamentary process are. The recommendation is that the section around the management of data needs to be reconsidered as it doesn't provide sufficient detail to meet the requirements of the Concord judgment. Where information is retained and examined for purposes other than the destruction of the material, it is material that it contains confidential journalistic material or identifies the source of journalistic material, then the judge must be informed. And that any details not dealt with in primary legislation should be included in regulations that are gazetted and released for public comment. The department's response is that the department is of the view that it is permissible for the Act to contain the principles within which the regulations must be made. The regulations will provide for the procedures to implement the required provisions. The process of making regulations involves public consultations. Therefore, the submissions made by the public are taken into consideration, and regulations can be subjected to the same level of scrutiny in terms of its legality as primary legislation. On Clause 9, which deals with laws amended, Ms. Jane Duncan has commented that there's insufficient guidance provided on the reporting requirements and what reports should contain. As a result, reports have hugely varied in terms of the amount and type of information, making comparisons across the tenures of several judges difficult. The standards contained in an international civil society document, as listed, for transparency should be considered for reporting. Reporting should be separated from authorization, which raises the question of the need for an independent reporting mechanism. This could be given to the Inspector General of Intelligence, then creating an entirely separate reporting mechanism. The recommendation is that the standards for reporting, as proposed in the document, be considered as the baseline reporting standards for the RICA judges, and that consideration should be given to making the Inspector General of Intelligence responsible for reporting on RICA intercepts to Parliament. The Department's response is that the comments are noted and will be considered during the process to overhaul RICA. We now move to the general comments received on the bill. Regarding SIM cards, Baker McKenzie, on behalf of Premium Idea South Africa, speak to the packaging and processing of SIM cards, and that there are loopholes in RICA which deal with the proliferation, or rather that fail to deal with the proliferation of unpackaged, duplicated, and or pre-RICA SIM cards and the consequences of this. Those include AML risks, CTF risks. They have implications for South Africa in grey listing as well. Premium Idea South Africa also submitted a comment themselves, and that comment speaks to trends observed regarding declining RICA compliance, with various low role players abandoning the effort to provide SIM cards in a secure packaging solution. This trend has implications for crime prevention and global perceptions in being removed from the grey list. PISA understands the limited purpose of the amendment in light of the Amabangane case, but believes that non-compliance and related shortcomings should be dealt with by the committee. There's a widespread dissemination of inadequately protected SIM cards, and that creates substantial risks, which subverts the intent of RICA and places consumers at risks. They speak to the role of MNOs, who play a significant role in stopping the dissemination of improperly packaged SIM cards, and that there is growing public scrutiny of MNOs in relation to the proper enforcement of RICA. The comment also notes that there are two SKUPIS incentives that affect SIM card distribution, and that are cost saving for manufacturers and incentive payments for service uptake. And those motivate shortcuts. There should be a cost for non-compliance with RICA that counteracts these incentives and promotes the security measures necessary for RICA's purposes. Another trend that has been noted is that of pre-RICA SIMs that are disseminated at the point of sale. This means that a distributor has been through the RICA registration in the name of a person other than the buyer. This circumvents the purposes of RICA because the SIM is untraceable to the user. They suggest that this can be eliminated through the proper packaging of SIM cards, and suggest that legislation should specify the minimum standards for packaging, security features, and verification protocols of SIM cards. They also refer to FICA and the Cybercrimes Act as being relevant to MNOs and their responsibilities. The department's response is that the comments are noted. The same comments were made in the Portfolio Committee, in particular by Baker McKenzie on behalf of PISA, and the submission relates to an issue which has been identified in the government cluster consultations and thus identified for consideration during the comprehensive review of RICA, and that process has been initiated. It's important to note that the department is considering not only the proper packaging of SIM cards in dealing with the proliferation of illegally registered SIM cards, but it's also looking more broadly at the entire value chain and all the role players in the SIM registration process. Also, RICA does provide for offences and penalties for non-compliance with its provisions in Section 51. In particular, Section 51 3A, 3B, 3C, and 3D deal with the offences and penalties for non-compliance with the SIM registration processes set out in Chapter 7. There's another general comment regarding the referral of the bill to the Joint Standing Committee on Intelligence made by V.L. Mashava, who comments that they're of the view that the department was obliged to refer the bill to both the Portfolio Committee and the Joint Standing Committee on Intelligence for dealing with the bill in succession, i.e. the Portfolio Committee and then the JSCI, and not in a joint sitting. The department's response is that the comment is noted. However, the department's of the view that the referral of bills to the parliamentary committees is not the responsibility of the department, but of the Speaker of the National Assembly and the Chairperson of the NCOP, should they deem it necessary. The department cannot recommend through which committee in Parliament the bill is processed, as that is the decision of Parliament. Further, the JSCI does not process legislation and its proceedings are not open to the public. It's unclear what purpose the deliberation of legislation under these circumstances would have. The chair and the majority of members of the JSCI are members of the National Assembly, and there was no objection from any of them when the bill was tabled for approval in the National Assembly. In addition, RICA deals with the issuing of interception orders by the designated judge, and the review of these orders and the post-surveillance notification by the judge. These are administrative decisions and not intelligence and intelligence-related activities. Advocate Mashava also referred to Rule 123 of the National Assembly Rules, but that's incorrect because Rule 123 deals with motions without notice. In any event, the JSCI is not a joint committee of both houses and doesn't fall under the joint rules, not the rules of either house. The next general comment is on process, and there were two comments made by Vial Mashava and Jane Duncan. Vial Mashava comments that the order requires the department to adequately provide safeguards to address the ex parte nature of applications and interception directions. This would logically require the department to consult with relevant stakeholders, particularly experts, in order to outline draft stipulations to give effect to this aspect of the order of invalidity. Ms. Jane Duncan comments that the bill should have been preceded by a review and a discussion paper setting out a comprehensive policy framework, deals with all amendments beyond the judgment, as RICA is an outdated piece of legislation and no longer fit for purpose. RICA needs to be reviewed in a comprehensive fashion, which the department has acknowledged, and the department should commit to a deadline in this regard. The department's response is that the process of legislative drafting within the executive requires consultation with key stakeholders, which has been undertaken in respect of key government stakeholders. The parliamentary process requires public consultation, and this process has been followed. The department has begun reviewing RICA and its committed timeframes to the Portfolio Committee. The Portfolio Committee, in its report to the National Assembly, urged the department to introduce the reformed RICA by the end of January 2025. The department proposed this timeframe based on the extensive nature of the work to be undertaken in reforming RICA. The department indicated that it will finalize the initial consultation process by the end of March 2024 and publish a bill for consultation during July 2024 with a view to introducing the bill in Parliament by the beginning of 2025. And the consultation and research process is currently underway. The next general comment is on Section 205 of the Criminal Procedure Act. And Ms. Jane Duncan comments that the bill misses an opportunity to address possibly the most serious surveillance control and oversight issue relating to Section 205 of the CPA. Her recommendation is that RICA could be amended in Section 15 to make it clear that if procedures are used in any other act for obtaining real-time or archived communication information, then RICA standards should apply, including the need to make use of metadata in an investigative method of last resort and to confine the applications to serious crimes. MNOs could become responsible for providing stats about the number of subpoenas granted to the RICA judge, and for the RICA judge to include these in the annual report to Parliament. The department's response is that the comment is noted and will be dealt with during the process to overhaul RICA. Furthermore, the provision, Section 205 of the CPA, is also under discussion in a parallel process where the South African Law Reform Commission is currently engaged in a project relating to the review of the CPA, and that process is currently underway. The next general comment does not fall under any of the above categories, and it's by S. Tao, who indicates approval for the bill, which aims to establish comprehensive regulatory measures to govern the interception of communications and the management of communication-related information, while incorporating safeguards to protect the rights and privacy of individuals. The department's response is that the comments received repeats the intention of the provisions of the bill without providing any substantive comments and inputs thereon, and the department notes the comment. That brings me to the end of the department's responses. Thank you, Chair.
Thank you very much, Ms. Boysa. DM or Ms. Blay, do you have anything to add?
Thank you, Chair. I have nothing further to add.
Yeah.
Chair, from my side, nothing either. I'll help respond to comments or questions.
Thank you, DM and the team, for providing us with the department's comments to public submissions. Our members, do you have any questions you would want to pose to the department and or any comment that you would want to make? Honorable Badenhorst.
Thank you very much, Chair, and the department. Thank you for the presentation. Apologies, I'm going to leave my video off. I'm not very sure about the bandwidth where I am at the moment. I think in as much as the Constitutional Court is relying on Parliament to draft legislation which obviously endeavours to find a proper balance between state security considerations and the rights of individuals targeted, it is concerning that the introduction of a public advocate to assist the designated judges, obviously with the purpose to bring to their attention matters and arguments pertinent to rights of data subjects, was refused by the department. And I noticed that in the feedback as well. Would the inclusion of a public advocate then be considered in the future review of RICA? And if so, why could it not be done in this version? And it's my contention that it's the responsibility of us as Parliament to present the best possible version of legislation to protect the rule of law, and in this case, obviously balancing state security with the very important privacy rights of the individual. So should we not consider that then, instead of just trying to rush legislation through to meet deadlines set by the court? Thank you very much, Chair.
Thank you very much, Honourable Badenhorst. Any other honourable member? Okay. Perhaps then, DM, if you could perhaps respond to that comment.
Chair, thanks.
Honourable Badenhorst, please.
Sorry?
No, please continue.
Okay. No, just to Mr. Badenhorst's comment. The issue, well, it wasn't just rejected by the department, it was rejected by the Portfolio Committee in the National Assembly as well. It's something definitely that would be considered in the general review of RICA. The problem with putting it in now is that it's not as clear-cut as it seems. We did look, and I think there was Ms. Buerta's highlighted the department conducted extensive research into that concept, looking to examples in other jurisdictions. And it's clear that there's no uniform approach. It's not a simple issue. There's also going to be the issues of, okay, well, how is this public advocate who is going to have immense responsibilities and access to serious information from law enforcement as to who law enforcement is wanting to intercept the communications of. And, you know, basically that process is going to be quite complicated as well. So the issue was, it's not something that can be rushed into. I know Mr. Badenhorst is from the Democratic Alliance. This was an issue raised by Honourable Glynis Breitenbach in the debate or the declarations on RICA, but we would still feel that and advise the committee that it's not such a simple process, and just putting it in, there may be a number of unforeseen consequences. So it is definitely something that we would be considering for in the general review, but it's not something we would advise putting into the bill at this stage because of unforeseen consequences. Thanks, Chair. I don't know if Ms. Buerta wants to add. I know Ms. Buerta's. I think maybe we should ensure, I don't know if it was done, Ms. Buerta, Ms. Pillay, that research document is given to members of the select committee for their information. Yeah, thanks, Chair.
Thank you, TM. You wanted to see if Ms. Buerta had anything to add? Ms. Pillay? Sorry,
Thank you, Chair. Chair, if I may come in. I see, is the hand still raised? Can I come in now?
No, please finish what the DM started,
Yeah.
or add to what the DM has said, then we'll take the hand later.
Thank you, Chairperson. I think I just want to add to what the DM said insofar as the research that we conducted. I'm not sure whether he covered it, but one of the issues that Alison highlighted in the document is from the research that we had done, and we had looked at quite a few countries which have a similar kind of system to protect the privacy rights, etc. And what we found is that in some parts of the world, legislation is actually more stringent than ours in some respects when it comes to surveillance. But we found that there's no uniformity insofar as the use of the public advocate is concerned. So therefore, in terms of what the DM is saying on broader consideration is required and debate is required when we develop the document, when we develop the new RICA bill, which we are currently doing. And I think when that bill is released for public comment, it will have to be also debated in the public space insofar as the options that we choose and why we are choosing them. Thank you, Chairperson.
Very much, Ms. Pillay. Ms. Buerta?
Thank you, Chair. I am covered by the DM and my DDG.
Okay, thank you very much. Barros, your hand was up earlier. I'm not sure if you clarified for now.
Yeah, Chair, it might be useful for us to have a look at that research material that the DM has referred to. And in as much as there would be unforeseen consequences with the inclusion of the public advocate, those unforeseen consequences will not go away in the new draft in the next term of Parliament. It will still be there. So I'm not 100% sure how the unforeseen consequences will be mitigated with a new draft, which then includes the public advocate.
Yeah, okay, maybe let me get the department to respond to that. I thought they explained it. Okay, but obviously we will get the research document as well. Let me then hand over, Honourable Minister. DM.
Sorry, thanks. No, look, the issue with the unforeseen consequences of if you put something into legislation without thinking it through properly and without subjecting it to wider consultation for other people to look at and make inputs, that's where you get the unforeseen consequences. So if you follow a more lengthy process of considering the option and putting it out for comment, consulting experts, consulting officials within government departments, particularly the police and state security, you're less likely to have unforeseen consequences. You're likely to have considered all the possible consequences of that provision. At the moment, I mean, we were sort of told, no, Ireland is the place to be. They have a public advocate. But when we looked at the Irish provisions, it didn't seem as clear-cut as it had been made out to be. So that's why I'm saying that it's something that needs more time to consider, because if we get it wrong, it could seriously undermine the whole system of intercepting communications, which is extremely necessary from a state security point of view and from a investigation law enforcement point of view. Thanks, Chair.
Thank you very much, DM. Any other member who would want to raise an issue and or make a comment? Okay, I'm not seeing any other member. Then, our members, I think the research document, then DM, if that could be provided to members, and the issue with regard to what Honourable Ross raised with regard to public advocates, obviously, as indicated by the department, that this will be considered in the broader review process of RICA. Yeah, but if we could please get that document as a matter of urgency. If there is no other comment and or input that members want to make, I just want to remind members that the deadline, obviously for this bill, the Concord deadline is the 3rd of February 2024, and we also intend have to finalize the bill in this week, so that we can then deal with it in the plenary in the NCOP next week before we rise for the constituency period. Yeah, so we would then convene a meeting later this week, possibly tomorrow, to then look at once again at the bill, as well as the report in relation to this bill. But that's why, DM, I'm proposing if we can get that report today.
Chair, thanks. Yes, obviously that report is on Ms. Buerta's, Ms. Pilley's, I think, my computer. I'll leave it up to Ms. Pilley to coordinate the sending of that report, but I'm sure that can be done within the next half hour, as soon as after the meeting is concluded. Chair, I just wanted to raise the issue, which was a new one that Advocate Mashava raised, and that was regarding that the bill should have gone to the Joint Standing Committee on Intelligence, and that's because of a provision in the Oversight Act, Intelligence Oversight Act of 1994, that it should consider legislation that affects state security, or I'm just going by memory now, or the activities of state security bodies. And that's a new provision. As has been said and Advocate Mashava feels that the department or the minister should have referred it to the JSCI. As has been said, it's not for the minister to do that. It is for the presiding officers of Parliament. And the process that members may be more familiar with is there's a provision in one of the laws relating to bills having to go to the National House of Traditional Leaders. And if it's going to affect, there's criteria for that, but affect customary issues. And that is done by Parliament. I think there's a decision taken on whether it needs to go, and then it's sent off, and they have about 30 days to respond. This one's slightly different because the National House of Traditional Leaders are not members of Parliament. So it's their opportunity to make inputs into legislation. The JSCI is a member of Parliament. I did also discuss this issue with Advocate Adikari, and who was also of the view that what's being provided for in this bill is an administrative process whereby administrative decision, whereby decisions are taken by the designated judge, whether or not to issue an interception order, whether or not, and then there's now the review judges who will review that decision. And then there's also the issue that the designated judge will decide on if there should be post-subject notification, or rather whether post-subject notification should be withheld for the reasons outlined in the bill. And those are not really security activities. Those are administrative decisions by the designated judges. So I just wanted to highlight that point. I did also discuss the bill with the chair of the Joint Standing Committee of Intelligence, who had informed me that he was happy with the bill, and I thought the committee was also happy with the bill. Obviously, you don't know what the JSCI discusses because they meet in their discussions and their meetings are in camera. So I don't think there's anything there. Also, maybe just to add, because I have been around some time. I was on the Justice Portfolio Committee that dealt with RICA originally, and I don't recall that going to the JSCI at all. So I just wanted to give, and when the bill went to the NA plenary, nobody said anything about this issue. There was no member of the JSCI who got up and complained that they should have considered it or they had a problem with it. So I just wanted to give that by way of further background. I don't believe Advocate Mashava is at all correct. Then he'd also misquoted some of the rules, and in any event, the JSCI falls under the joint rules of Parliament, not of an individual house. I just wanted to add that. Thanks, Chair.
Thank you very much, DM. I'd actually forgotten about that, for providing that additional clarity on that matter. I'm not noting any other hands from honourable members. I think that we said DM.
Sorry, just one quick thing, just on the issue of the document. I see on my computer that Ms. Pillay has sent it out already to Gershwin. So it is, Chair, it is in your domain.
Okay, thank you very much. I was just going to close on that as well. For the document, the research document, honourable members, you will receive it today or immediately, following, as soon as Gershwin can send it to you. We've come to the end of this meeting. Let me thank the department and the legal teams for providing us with the necessary input into public comments. And let me also thank honourable members for their input as well. As I've indicated, honourable members, you will probably meet, I think, tomorrow to then also re-look at the bill as well as look into the adoption of the bill and the report. Thank you very much, honourable members. This meeting has come to an end. Thanks.
Thanks, Chair.